A significant difference, as most people know, between a misdemeanor and a felony, which are the only two types of criminal offenses under Arizona law. Generally speaking, a felony is any offense for which a person can be incarcerated for 1 or more years. So basically, if you can get a year in jail or a year in prison or more, then it's by definition a felony. The maximum penalty for a misdemeanor, including a class 1, the most serious misdemeanor, is 6 months in jail. So that's technically the difference, but there are so many other ramifications associated with felonies versus misdemeanors, but that's the basic definition. So all basic DUIs, first offenses and second offenses, the ones I've described so far, those are all listed as misdemeanors. A DUI can become a felony DUI, which we should look at as well in just a moment. But first, if they're all misdemeanors, why are they defined differently? It's kind of important to think about that. You have impairment to the slightest degree in a .08 versus somebody who maybe has what's called a super extreme DUI. We talked about a .20. So why does, if they're all just misdemeanors, who cares, right? The reason it's so important is because the legislature has decided that for each one of those, as they become more serious, as a person faces a higher level of impairment, so extreme DUI, super extreme DUI, the mandatory minimum penalties go up and up and up. And then the highest one with the most mandatory penalties is what's called aggravated DUI. So felony DUIs under Arizona law are called aggravated DUI. Really quickly, aggravated DUI comes into effect by definition if you basically commit a misdemeanor DUI, but at the time you do it, you weren't even supposed to be driving anyway. You're suspended from driving, your license is revoked or canceled, or you're on a restricted license that you're in violation of in some fashion. So we'll talk about ignition interlock, for example, later on, but a person who has what's called a special ignition interlock restricted driver's license, or SIRTL for short, a person who commits a DUI and had someone else blow into the device in order to start their car, they would be in violation of their restriction, and that DUI just jumped up to a felony or aggravated DUI. A couple other ways that can happen is anybody who is supposed to have ignition interlock, if they get caught driving any other vehicle that doesn't have it installed and they commit a DUI while doing so, felony DUI jumps in. Another one is if you have a passenger, a child, under the age of 15. Notice that the legislature didn't just say a minor under 18, they specified under 15. So technically, if you had a 16-year-old passenger and you committed DUI, it's still a misdemeanor. But if you had somebody who, say, is 13 and in your vehicle while you committed DUI, you're going to jump up to aggravated DUI or felony DUI just on that fact alone. One other way is, and this is probably the most significant one, a person who gets a third or subsequent DUI in that 7-year period that we talked about. So first offense is a misdemeanor, second offense is a misdemeanor but with higher penalties, higher minimums, third offense in 7 years, automatic felony, very, very difficult to defend, so very, very serious, and it's punished very, very seriously as well. So back to the plan for today. That's a general overview. We just defined essentially every single DUI statute that identifies or defines a DUI offense under Arizona law. So taking a step back, we've talked about the offenses, but if you're actually arrested, what happens next? That's what we're here to talk about. The arrest itself, we're not covering because it just takes too much time, and that's really important to think about. It takes too much time, and maybe in the future we can talk about it because it's just complicated, but standardized field sobriety tests, the walk and turn, the roadside tests that an officer may have a person perform if they're under suspicion of DUI. The one called horizontal gaze nystagmus, or HGN for short, sometimes called the eye test, where they're moving a stimulus across your field of vision and seeing if your eye has any nystagmus associated with it, which is a sign of possible alcohol impairment. Those are things that the officer may do on the side of the road, as well as noting the odor of alcohol. If you're stumbling, if you're having difficulty with what they call divided attention tasks, you're trying to talk to the officer, you're trying to get your insurance card, and you're not able to kind of do both of those things. That's common with people who are under the influence, and it's a possible sign of impairment. So all of those things are happening on the side of the road. Ultimately, what's really important is the officer must have probable cause So they must have more than just a reasonable suspicion of DUI. They must have that added element, that just a touch more evidence to hold up in court before they arrest you. So if they arrest somebody, they've now determined that they think they have probable cause to arrest, and you can challenge that in court if you don't think they had enough evidence at the time they committed the arrest. And that's true even if later on you tested positive for alcohol, even above a .08, but at the time that the officer arrested you, they didn't know or have sufficient evidence to support a finding of probable cause. You can challenge that in court down the road. So probable cause is the key phrase for the level of proof required to actually arrest somebody on suspicion of DUI. Once a person is arrested, one of the biggest things, among others that will happen, but one of the biggest things will be whether you end up providing a sample of your breath, blood, or urine as discussed in the DUI statutes. The officer has the legal right to request you to provide any combination of those, just one of those, or all three of those. Generally speaking, urine is not used often because it's not scientifically sound. Often the testing for it is not forensic enough to make it into a courtroom or be convincing enough that they can prove when a person consumed, if they were impaired. So the two typical ones for DUI cases would be breath and blood. A big question will be, what if you refuse? They can't get a sample of your breath because it requires you to actually willfully provide that sample. So if a person is seeming to be impaired and they've been arrested on a finding of probable cause and they're transported over to the jail or police department where they have these testing procedures available, and the officer says, I want you to do a breath test, technically people do have the right to refuse, but you should know as well that that refusal could be used against you, both in the criminal case, and then we'll talk about the MVD case, the license suspension case against you as well. So the other option is to not refuse. If you refuse breath, the other option as well for a police officer is to then go and get or apply for a search warrant. So they can apply, including in the middle of the night. They have these forms called telefax search warrant affidavits, and they will fax it to an on-call judge who's basically agreed that, for a particular weekend, they'll be on call. And maybe in the middle of the night, they get woken up, and an officer says, there's a fax, I'm sending you a fax. It's an affidavit for a search warrant for someone's blood. I asked for breath, they're refusing. Here are the reasons I think that they're impaired. Here's the evidence I have for probable cause. And if the judge agrees there's probable cause, then they can issue a search warrant. That gets a little dicey because if a person is really refusing, they won't stick out their arm for a needle, because really what that is, the search warrant is a court order that the government can bring a needle, stick it in your arm, and literally extract your blood against your will. And for some people, they see the search warrant, of course, and they say, fine, it looks like a valid court order, I'm going to comply. The other option that's not advisable, of course, but some people will refuse. They literally at that point can strap you down, hold you on the ground, stick a needle in your arm against your will. Those are horrible videos. I've had plenty of clients over the years where I've seen it. They can strap you into a phlebotomy chair, it's called. I had one where they held somebody with multiple officers, just held a person who's screaming on the ground and stuck a needle in. But you need to be aware if there's a valid search warrant, you need to comply. So they'll get the breath or blood one way or another, typically. Then the officer has a decision. If it's a breath sample, you're going to have the result immediately. So you can ask them, what does it say? I want to see it. And usually they'll have no problem showing you because it's right there, they have it, and frankly it's something that you're going to see later anyway. But even if they won't show you, they still have to make a decision. Do I release this person or do I book them into the jail? If they had probable cause to arrest you for DUI, and if you give a breath sample and they have above a .08, they have every legal right to book you into jail. In some cases, and when you're thinking about why would an officer book somebody or release somebody, there's really no clear answer. Every time I've asked an officer that during interviews, some of them say, I just have my own policy on this. If they're above a .15, I'm booking them. If they're not, I'm probably not. Other officers say, well, if they're really cooperative and polite with me, I'll probably release them to a sober third party if they have significant other, a roommate, anybody that I can meet, trust that they're sober, and say, will you take custody of this person, make sure they don't drive, make sure they go to bed, then I'll release them. And other officers say, you know what, if it's above an 08, or if I don't even have the result, I'm booking them because they're just going to jail because I think I had enough evidence of a DUI. I'm taking them off the streets, and you'll see a judge within 24 hours. And typically you'll be released afterwards. So that's kind of a decision that is really left up to the officer right then and there. It affects you only insofar as if you get booked into jail. Even if you don't spend 24 hours, the good news is you're going to get credit if you're ever sentenced to jail on a DUI. Even if it's only one day, you're going to get credit for the fact that you were booked into jail. So actually, if you were booked at 3 a.m. and you see a judge and you get released at 10 a.m., you only did 7 hours, but you're going to get credit for a full day of jail. So if you're later sentenced to 1 day in jail, you don't have to go back. You already did it. So that kind of benefits, at least you get the back-end benefit of that. If you're released, even if you were arrested, it does not count. Even if you were held against your will, it does not count unless you were actually booked into jail. So there are two cases ultimately that get filed if you have a DUI arrest. One will be the criminal case. That's the DUI, .08, 15, extreme, aggravated DUI. Those are all the criminal charges possible. But then there's an entirely separate case, and most people don't know that until they go through something like this, and that is a administrative case through MVD or ADOT, the Arizona Department of Transportation, and its subdivision, the Motor Vehicle Department. And that one has no criminal penalties associated with it. It's purely administrative. So it's part of the executive branch of government. The criminal case is part of the judicial branch. So they're really, really separate. They have the same set of facts because it arose from the same arrest, but they're very, very separate. The criminal judge and the judge in the administrative case, they will not communicate. They will not know what each other are doing. They don't work together. So it's just, in your mind, it's more helpful to keep them separate, even though they came from the same set of events. So we've defined the criminal DUI charges under Arizona law, so let's just take a minute now and talk about that MVD aspect. So you're arrested for DUI. You know you have the criminal case. They'll give you information about that. You might be summoned to court, but we'll then address the other thing that needs to be on your mind, and that is, I've got an MVD case. I've got the possibility that the MVD is going to suspend my driving privileges. All right. The MVD case begins with a document. It's kind of like the criminal cases, where the criminal cases have a complaint or an indictment. The MVD case begins with a document called an admin per se, implied consent affidavit. And essentially what that is just the officer saying, I arrested this person, and they identify the reasonable grounds that they had to believe this person was possibly a DUI driver. And then if they took a breath sample, they put the result. If it's a blood sample, they're not going to have the result for probably, right now it's somewhere in the vicinity of 2 months, 60 days, just whenever the lab can get that done. But they're going to file this document, and this document leads to that MVD case. What it looks like, this is what the document looks like. And really, out of all that, it's all the information the officer fills out, but these last two paragraphs at the bottom are really important. The top one, I know it's not legible on here, and actually I pulled this from the ADOT website and it was already blurry, but the top one is in reference to what's called a refusal suspension, which we'll talk about. And the bottom one is in reference to a suspension associated with being above a .08 or having a positive sample for a drug that's illegal to drive with. So those are two different suspensions. On the left side, the officer is going to check one of them, and that's it. And that's the one that you're facing. That's the allegation you're facing. So it's just one of two. In the MVD case, the refusal case and the .08 or drug case have different consequences, but you treat them very similarly in terms of if you want to defend against them. In the refusal situation, so if you refused to provide that breath sample, or if the officer asked for urine or blood and you refused to provide it, then at risk to you is a 12-month suspension of your driving privileges. And that's for a first refusal. I'm not going to go into the details of what it means if you've had a previous refusal and you do it again. You're going to have a more significant suspension. But this is all going to be in reference to first-time offenses. But you're at risk of having a 12-month suspension. And remember that word SIRTL we talked about? It means Special Ignition Interlock Restricted Driver's License. and that's a restricted license where you have to have the device to blow into to make your car start. After 90 days, the MVD can, but they don't have to give you a CERTL, a restricted license. So you're either getting 12 months for refusing to provide a sample, either 12 months or 90 days plus. You'll have to do the remaining, essentially 9 months of that on a CERTL device. All right. So remember 12 months, and then if you compare that to somebody who does not refuse, at risk for them, if they blow above a .08, for example, is really a lot less. And instead of a 12-month suspension, it's a 90-day suspension. And the good news is, this is not discretionary. The MVD absolutely will give you a restricted license after 30 days. So essentially, you can be stopped from driving for a refusal for up to a year, and if you don't refuse, but you do blow above a .08, for example, you're really looking at about 30 days without any driving, okay? No exceptions, not everyone, but I got a lot of questions about what if I work and I drive for work? What if I drive at work? What if I live rurally and I have to drive to get to work? There are no exceptions. They took them all out of the statutes a long time ago. There used to be some, but there are none. Everybody would have to do 30 days. I call it a hard suspension because there's just no exceptions, all right? Where does that leave us? So separate, remember, from the criminal case, and it'll be held not in a courtroom in, say your case happens in Flagstaff, Arizona. The actual MVD case is going to be out of Phoenix. It's going to be a place called the Executive Hearing Office in Phoenix. The good news is MVD will allow people to appear by phone, or in some jurisdictions like Flagstaff, at the MVD they have a video conferencing on a closed circuit television situation that goes straight down to Phoenix. So the judge will be in their office at the Executive Hearing Office with the camera, and we would be in the MVD office, and the case would proceed by video conference to avoid unnecessary travel for everybody involved. The 15-day deadline, what that is, and that's all in that admin per se document that I showed earlier, but it's very, very important. If you want to challenge that suspension, you have 15 days from the date that the officer hands you that document. So if you're arrested, they'll typically hand it to you right then and there. But in any event, whenever they hand it to you, that's the date you're served with it. And you start calculating from the date served 15 days, where you can file a request for a hearing or a request for what's called summary review. The request for hearing will generate, guaranteed you get a right to a hearing. If you request summary review, it means a judge is going to look at it by itself and see if the document is sufficient or not. You will not have a hearing if you request summary review.